Yes.
Okay, so good afternoon, Your Honor. May it please the court. My name is Cal Morris. I'm Aaron O'Leary, who represents the appellant Trilogy Old Farm. This is a case that comes before the court after the entry of summary judgment by Judge Barton below. Judge Barton accepted the tenant's interpretation of the lease, which we submit is at odds with.
I'm sorry, who did you say the judge was?
Barton,
Who?
Senior Judge Barton.
Oh, because I have a different one here.
Yeah.
Okay, I'll make sure we have the correct judge. All right, thank you, sorry.
It's this one I have.
Okay.
He signed a summary check.
Yes,
That's the
Okay.
other deal. The other one made done everything else.
yes, yes.
Okay,
This is
all
the
right.
end.
I'm sorry to interrupt.
No, that's fine. So as we've said, they were just referred as the trial court. The trial court entered summary judgment, which we believe is at odds with the controlling principles under Florida law with respect to contract interpretation. This is a case that really devolves down into two contrasting, or more appropriately, conflicting interpretations of the lease contract here. The tenant claims that the business cessation provision of the lease creates a situation that if the tenant avails itself of that unilateral right, it is not a default and it's not a breach of the lease. In contrast, the landlord contends that under section 8.2 of the lease, there is a 1-year continuous operation provision or requirement by the tenant, which was an anchor tenant in the shopping center. And that 1-year provision is, according to the lease, subject to only permitted cessations. Here, this case arises before this court.
It's a 10-year lease,
Yes,
which nobody really talked about. And I think if you put this in the context of a 10-year lease, it makes it a lot easier to come to a conclusion about how to read these other provisions.
I think that's right, because there's two, if you will, periods in the lease. There's the first year period, which under section 8.2 provides very unequivocally that the tenant will continuously operate for a period of 1 year after its opening. That's a little bit of a, if you will, an abridgment of it. But it also says, however, subject to permitted exceptions. And then goes on to say.
But this isn't really about, this was a permitted
was
cessation.
not.
We don't care about that. That's
No.
not an issue.
Those are not an issue at all. And I
Okay.
think that's an important position to start from because it is subject to permitted exceptions, which are not claimed nor alleged here. And therefore, the 1-year provision is absolute. There is no permitted exception. There is no subject to that comes into play. Here, the principles of contract interpretation that the Florida courts have enunciated candidly for years are that the provisions in the lease, which is a contract, are to be read as a whole, to be read reasonably, and to be read harmoniously. But most importantly, you cannot read into or out of a lease or written contract provisions. And we submit that that is exactly what happens when you look at the trial court's ruling and the manner by which the contract seeks to be interpreted by the tenant.
I have a question. Didn't the landlord also terminate the lease
Yes,
and take possession, change the locks?
yes.
And they did that under the exclusive remedy clause?
No, the trial court found that they did it under section 16 of the lease, which is another remedy clause. I believe the exclusive remedy clause that you're referring to is the exclusive remedy if there is a business cessation. But here, because there could not be a business cessation within that first year period, because again, that period cannot be subject to business
So
cessations.
you're saying there's a 1-year exception to the 10-year lease. You gotta stay there for 10 years. If you don't stay there for 10 years and you move out, because the landlord found out they moved out like 3 months beforehand. Then the landlord retook the premises. At 3 months beforehand, they move out, landlord finds out, so they're six to 9 months into their 12-month period.
Right.
And then the landlord terminates the lease, retakes it, and allegedly re-rents it. I mean, that was the intent, I'm assuming.
Sure.
So you're saying it doesn't matter, you can retake it even if it's within 12 months without actually saying that's your remedy.
Yes, because the way the manner lease is brought to us, it's brought with first mandatory language that the tenant shall operate continuously, not may, not could. And it is also brought to us only subject to very limited exceptions, i.e. the permitted exceptions, which are not at issue here. So what happens in this is when you read the lease, as the court has suggested, Judge Kelly, in these two periods, the 1 year and then the thereafter, the last 9 years, the lease, I think, comes into much sharper focus. The next sentence in section 8.2 makes clear that thereafter, after that
After
first
the
year,
1 year.
after that 1 year, there is no continuing obligation to operate. And that's when they can simply leave, essentially as a unilateral act, which is a business cessation. The business cessation provision in the lease, 8.2.1, when you read through it, it's very clear. It's simply, we've decided to go dark. It's not we've decided
If
to
you
go
do that in
dark.
the first year, it's a default, but if you do it after the first year, it's not a default.
Correct, and that would be our position. However, to read it that it is available in the first year lacks harmony in the lease provisions. What it does is it simply rewrites section 8.2 and rewrites it in a very fundamental fashion. It rewrites it to say that it is subject to permitted exceptions and business cessations, and that is not there. Clearly, the drafters of the lease, and the lease has a provision in it that it is not construed against either party, it's an arm's length transaction. But clearly they knew that there were certain permitted exceptions and there were certain business exceptions or cessations. They did not include business cessation as one of the exceptions to that 1 year period.
So the relief you're asking today is simply to reverse the summary judgment, but not to reverse to enter summary judgment. It sounds like you have a summary judgment argument, but that's not before us today.
It is only to the extent that the case went into trial court on cross motions. And I believe that to the extent that the court would find that it was interpreted below incorrectly,
Well,
the court could.
that's between you and the trial judge.
Yes.
You didn't appeal the denial of the cross motion.
No, we both appealed it, they're cross appeals.
You did cross appeal in this case?
Yes. Well, we actually filed the appeal because it was entered in favor of the tenant.
I only saw two issues. Okay.
But I think the point is well taken, that a remand to effectively consider the two provisions or two periods of the lease could be an appropriate remedy here, because as we've indicated, that provision in the lease that the parties agreed to and went into willingly makes very clear that you can only quote unquote get out of that first year for a permitted exception, or you suffer a breach. It's in the subsequent years that you can effectively go dark without breaching for a business cessation purpose.
Well, counsel, I assume that these are fairly high-risk types of leases on both sides going into a shopping center and things. I mean, couldn't in trying to effectuate the language of the contract, couldn't we think that the parties bargained for this type of agreement, this type of out, because it doesn't only give the tenant an out, but it would give the landlord an out if the tenant ceased to operate below 50%. I mean, they could not linger in the shopping center if they're operating at 30 or 20%, even if they wanted to after the 4-month period. So, I mean, can't we look at it like it's actually a bargain for benefit from both sides? It eliminates some risk for the landlord and eliminates some risk for the tenant as well.
It does eliminate risk both ways, and the way the lease addresses that, if you will, limitation of risk is for the tenant. It says you really are only at risk for that first year of continuous operation. For those other 9 years, if you need to go dark, you can go dark without it being a breach under 8.2.1 of the lease. It limits the risk for the landlord and the converse. It says during that first year, they will continue to operate, and it will be a continuous operation, or it will then be a breach of the lease, other than if it's permitted cessation. So there's the protection on both sides. Why, you may ask? It's not really in the record, but we all frequent shopping centers, and there are anchors in shopping centers. This is an anchor. And as we know, when the anchors go, the shopping center has problems otherwise. So it's something that allows, from a business perspective, the landlord They have the certainty of that anchor tenant being there for year one or suffering a breach if they leave or fail to
Well,
operate.
even if it's a business cessation, there's a 4-month period, so that's 120 days, and then there's a 60 to 90 day notice, provision. So you're almost up to 8 or 9 months at the least, right there.
You could be almost up to it, but it doesn't take away the fact that it was not the permitted manner by which 1 year of continuous operation could be breached or could be avoided. It's very clear in the lease, and the lease says it shall be subject to permitted exceptions only. It doesn't say and business cessations. So
Well,
essentially-
the point I was making is that it because you can extend the time so long under the business cessation, it doesn't make the 1 year, provision so out of whack with interpreting that they run parallel at the same time.
It may not, but what it does do, it takes away the ability for the landlord to have a cause of action or a claim under the lease if the business cessation can be used that way. Here, however, because we submitted it cannot be, the trial court was incorrect in granting summary judgment to the tenant. Rather, it should have either had the case go forward or granted summary judgment to the landlord, so it could then consider exactly what Your Honor is suggesting, which would then go to the questions, what are the damages for that breach? The trial court never reached damages because it stayed damage discovery, and therefore that was something that the record is really silent on and we can't even go to at this point. So I believe what Your Honor is suggesting really suggests to me that the trial court erred, and the trial court should have read the lease as written, should have said this is a business cessation because, as Judge Kelly suggests, there's no argument that it was permitted cessation, and that's a breach. And because that's a breach, that is why this case should be reversed.
I mean, the trial court said it was a business cessation, you say it's default. The
Well,
trial
the
court
business-
said, let me just say
Sorry.
something. The business cessation problem, the trial court identified as, there's nothing in the lease to say the business cessation cannot occur during the first year.
It doesn't say that specifically, but it does
So
use
if
the
it doesn't
language.
say that, then the judge was free to exercise discretion, okay, that's a cessation. They paid up until the time they got the notice. The notice says, give me the place back, right? They give you the place back, you don't also continue to get money. You ask for possession, you got it. If you ask for it, you didn't have a tenant, then, and you can't collect double rents anyway, you have a duty to mitigate, so I'm not sure the trial court is necessarily wrong, even though the lease might be ambiguous.
Well,
And if it is ambiguous, then it goes back to a summary judgment can't be granted on an ambiguity.
right, and I think there's 3 things when we unpack that.
And both sides stipulated it's
Right.
unambiguous.
Well, I think the first thing is we talk about ambiguity for a moment. Yes, both sides move for summary judgment, thereby suggesting that there are no questions of fact and no ambiguity.
And I didn't
However-
see that anybody's arguing that there's a question of that.
And nobody's arguing that, but if this court ultimately decides that there is some
It seems,
tension,
it seems
yes,
to me that what, and maybe I'm oversimplifying it, the question is, can you cease operations during the first year and not be subject to the default provisions in section 16 of the lease, right?
Right.
Okay, and there's no argument that this was a permitted cessation, it's like they ceased doing business. And the question is, is the remedy limited, like by this thereafter clause, or do you go to section 16?
I think you go to section 16.
Right,
Because the
okay.
thereafter clause is
Right, well,
what happens
I
in
mean,
years 2 through 10.
my reading of this is that you have to continuously operate for a period of 1 year. Thereafter, after 1 year,
Right.
nothing in this lease shall be deemed to impose any further obligations on the tenant to operate the premises or any portion thereto during any portion of the term. So it references back to the 10-year term.
Right.
So you have the 1 year, and then you have the 9 years and the overall 10-year term.
Right.
And you have one remedy if it's during the first year, and you have a limited remedy if it's after the first year.
Right.
Is that
I think that's
your
correct.
argument?
I think that is correct. And that I think is where the trial court erred, is it conflated them together and said because it's a business cessation and in 8.2.1 it says that shall not be.
Right,
Right.
the trial court disregarded whether or not it was within the first year or during the remaining 9.
I would essentially say that's correct, yes, Your Honor.
Okay,
And that I think is the error here. And that's why I believe that the case should be remanded back to the trial court.
Well, didn't the trial court actually, I mean, just say that that a business cessation could happen during that first year because your first section, 8.2, doesn't say that it can't.
It does, I believe. It says it can't in this regard.
well, it can happen, it can happen. I mean, there's no question that a business cessation
Yes.
occurred. The question is, what is the remedy if it occurs during the first year? Am I misunderstanding?
No, I think you're correct, and perhaps I misspoke a little bit when I said that it can't be in the first year. What it can't be in the first year is an exception to the 1-year operation provision. And therefore, it's a default of that if you use a business cessation to stop operations in that first year.
Well, then if it happens in that year, then it's based on your interpretation, it is a business stoppage, but not a business cessation based on the language of the
Which is a breach.
statute.
Right, which is a breach, which then would have suggested that the trial court erred by permitting summary judgment to be entered in favor of the tenant in this case.
Okay. Oh,
I'm sorry.
I'm sorry, because I let you go a little bit longer, so you are at your rebuttal time. You
Okay.
Use your time however you like.
I can use it for a moment,
Okay.
thank you.
All right, you still have 4 minutes.
Okay.
Good afternoon, and may it please the court. Alyssa Corey on behalf of Appalese CWI Inc. and CWGS Group LLC that I'll refer to collectively as Camping World, our tenant. This court should affirm the trial court's grant of summary judgment in Camping World's favor for 2 reasons. First, the plain language of the lease in section 821 unambiguously states that a business cessation is not an event of default. And second, the trial court did not rely on disputed facts concerning damages in its interpretation of the lease.
What about section 8.2? I mean, you're looking at 8.21, but don't you have to read that in context with, number 1, the initial term of the lease is 10 years. And then you have 8.2, which puts this obligation to continuously operate during the first year.
Yes, Judge Kelly, and when looking at section 8.2, we think it's important to look at not only the thereafter language, but the language that follows, where it states.
You're going back up to 8.2 now?
Yes,
Okay, it says thereafter, in other words, after the first year. Nothing in this lease shall be deemed to impose any further obligations on the tenant to operate in the premises or any portion thereof during any portion of the term.
and then in section, yes, Judge Kelly, but then in section 8.2 continues, the duration and manner of tenant's business operations, if any, shall be determined by tenant in its sole and absolute discretion. And it does include a qualifier that obviously the tenant's stores are going to operate in the same manner consistent with hours in the southeastern part of the United States. But it's nothing in this sentence shall be deemed to impose a covenant of continuous operation on tenant after the foregoing period. So after that first initial year of continuous operation, there's no obligation
Right,
whatsoever.
we're in the first year.
Yes, and so that's why these parties created a specific right of landlord, as Judge Stevenson pointed out, noting the fact that in that first year, there is, a desire for there to be a continuous operation. Should landlord, exercise the right to recapture that's identified in 821, if the business cessation conduct occurs by a tenant, it provides a right that would not otherwise be available to landlord to recapture the premises and terminate the lease.
Well,
in that
I mean,
initial
there's a
year.
remedy under section 16 for default.
Yes, but here the plain language of the lease 821 specifically states that business associations shall not be deemed to be an event of default thereunder with no qualifier. There's no, this only applies after the initial first year of continuous operation.
Well, you have to read it in context with the obligation to continuously operate in 8.2, don't you?
But reading it in that way, Judge Kelly would render 821 meaningless if tenants
Well, no,
obligation.
because I mean, 821 is talking about in the thereafter, isn't it?
No, that's not our reading of the lease.
Okay.
The thereafter clause and the clauses that follow speak solely to the obligations of tenant following expiration of the initial year. And that is, you know, the duration and manner of tenant's business operations after that initial year, if any, shall be determined by tenant in its sole and absolute discretion. And so that's why the initial 821.
So really, this
association
first
applies.
sentence, this first part of section 8.2 is kind of meaningless. That imposes an obligation to operate continuously, because you really don't have to.
No, Judge Kelly, what happens in reading 8.2 and 8.2.1 together is that there is still an obligation that's not negated by the inclusion of 8.2.1. It's just specifically defined conduct, you know, ceasing business operation in more than 50% of the premises on a substantially full-time basis that provides a different right to landlord that would be otherwise unavailable to re-enter, recapture the premises and terminate the lease. Speaking exactly to what Judge Stevenson was talking to as to, you know, the maintaining of a tenant in that premises in the initial year.
Well, let me ask you a question then. Why does the lease need to say that after a year, you're not deemed to have any obligation to operate continuously? Why do we need that?
Because that is the bargain for language under the terms of this lease.
What? I'm sorry?
The bargain for language under the
But why
terms
do
of
you
this
need it?
lease.
If you have no obligation at all, why do you need to say you don't have any obligation?
And that's exactly the type of conduct that 8.2.1 is speaking to inside of that initial year.
So your position, let me just make sure I understand. Your
Yes.
position is that if you cease operations, it doesn't matter if it's within the first year or during the remaining 9 years of the 10-year term, the landlord's remedies are the same.
No,
Okay, then help me with that, because I'm not sure I'm following you then.
so our position is that in 8.2.1, for a business cessation to occur, there's specific conduct that the parties
Right.
identified. And so though that conduct shall not be deemed to be an event of default hereunder.
Right,
And so then, following the initial expiration of the continuous operation covenant, there is no obligation on landlord to operate outside of the fact that the duration and manner of tenant's business operations, if any, shall be determined by tenant in its sole and absolute discretion.
yeah, after the first year.
But that doesn't negate the fact
But
that.
the same thing, but you're saying, yeah, that's all after the first year, but the same thing applies during the first year,
Yes.
correct? Okay,
As
but
it-
there's no difference in how you're gonna operate or what the remedy's gonna be.
As
It's the same for the whole 10 years. Is that wrong? Am I misunderstanding?
Camping World's position would be that the business cessation provision applies during the initial year term. And then how the parties conduct themselves is not defined by that provision moving forward.
Okay,
But to read the lease in a way that 8.2.1 doesn't apply during the first year requires a rewrite of the lease provisions to insert exclusatory language specific to the first year or only applies in the remaining terms of the lease. And when a contract is clear and unambiguous, the court's role is to enforce the contract as written not to rewrite the contract to make it more reasonable for one of the parties. Landlord's interpretation hinging on a construction of tenant's business cessation conduct as an event of default until expiration of the 1-year continuous operation covenant in 8.2 is unreasonable. And it would require rewriting to add language that says something like after the first year,
Well, it does say after the first year.
but not when we're looking at the specifically defined conduct that would be triggering a specific right to landlord in 8.2.1, which expressly states a business cessation shall not be deemed to be an event of default hereunder. And so you don't get to those section 16 remedies unless there's a breach. And here, there can be no breach under 8.2.1 if the tenant's conduct arises to the conduct specifically defined as a business cessation.
Well, that was the term of art that the court used in the summary judgment. If it didn't have an exclusive 1 year in the business cessation clause, then it could apply from day one. Wasn't subject to that 1 year continuously doing business. Is that true or false?
Correct, so there would be, the business cessation could apply in first year.
So there's internal inconsistencies with the lease. Doesn't, but apparently both sides said it's not ambiguous. And the court went along with that, said, you just have an interpretation problem, I'll figure it out. And that's how the judge figured it out. Use that, that was a pivotal moment in the order, the way I read the order.
Yeah, and you're correct.
Otherwise, it looks like a loser today. But the judge said there's no reason not to apply during the 12 months, even though the lease says you gotta operate for 12 months. It says if you cease business, the landlord has an exclusive remedy of taking the place back. And I guess the tenant continued to pay the rent until they got the notice. The notice said, give me the place back. So I'm thinking, who in their right minds would keep paying the rent when you don't have the keys? They probably would have kept paying the rent, but they're not operating a business. The landlord has said you're not operating a business, and someone made a mistake somewhere. That's why they ended up in court. I assume it's big money to pay that rent for each month.
And that was in compliance with the lease terms as the parties move forward, because as you'll know in section 8.2.1, this is a right that is exclusive to landlords should they exercise it. You know, just because tenant's conduct arises to specifically define conduct of business cessation, that doesn't mean that landlord has to exercise that right of recapture. And so,
But that was the reason why they exercised the right. They hadn't been there for 3 months. They said, you're gone, you cease business, I'm gonna rent it out. They wanted to have a fully occupied center, whatever the deal was.
and that's exactly why the specific right was negotiated for.
And the tenant never stopped paying rent until it got the notice.
Correct.
That's what makes me wonder why they make a mountain out of a molehill for money to support them. You can't get your cake and eat it too, and that's what they're trying to do. And they're trying to say the lease is not ambiguous in their favor. The tenant said just the opposite. But someone's actions is inconsistent with the lease. It looks to me like the landlord had a problem here.
Yes, and that's how the landlord responded to tenant's conduct that was in congruence with section 8.2.1. And the language of the lease is explicit, that's not an event of default. And so landlord could not avail itself of the remedies in section 16. It had to use the remedies specifically identified for recapture and termination of the lease in 8.2.1. Regardless of when that action occurred in the initial year. So the inclusion of the business cessation provision doesn't negate tenant's obligation to operate in the first year. And you know, there's lots of conduct that we could discuss that would get into a default provision, but that's not what we have here. There's no disputed fact about the type of conduct that existed or that conduct fell within the specifically defined conduct of tenant in operating a business cessation. And landlord's interpretation is unreasonable and asks this court to not only ignore the plain language in section 8.2.1, but requires rewriting that provision to include language that would preclude application of section 8.2.1 in the first year of tenant's operations on the provisions. Now, if this court found that there was a conflict in the provisions, the principle of general and specific would allow the specific provision in 8.2.1 to prevail over the general continuous operation provision in 8.2. And this would, in applying this principle, the specific provision would modify but would not eviscerate the general principle in section 8.2 of continuous operation. Therefore, the natural consequence here is the absence of liability. And because if there is no event of default by a tenant under the lease, all of landlord's counterclaims and defenses fail. If there's no further questions, we ask this court to affirm the trial court's grant of summary judgment in Camping World's favor. Thank you.
Thank you.
Florida law provides the principles by which this court or any court needs to interpret a written agreement such as the lease. As we've heard repeatedly this morning, including from the tenant, the lease must be read as written and harmoniously with each provision. However, the suggested interpretation by the tenant is anything but that. Rather, what the tenant is suggesting is that the 1 year period is illusory, and it can simply be written out of the lease because they can cease as a business cessation whenever they choose to, even within that 1 year. That takes away a very specific contracted for language that 1 year provision is only subject to permitted cessations, not as the tenant suggests, permitted and business cessations.
Council, and not to parse too finally here. Could this be interpreted as the parties saying point blank that when you have a business cessation, it shall not be deemed to be an event of default?
Only if that was the only provision of the lease. When you read it in the context of the entire lease, which is what I suggest Florida law suggests we need to do, and you look at 8.2, there are many provisions there, starting with the subject to permitted exceptions, talking then about thereafter there shall be no continuing operational requirement, i.e. you can then use a business cessation. And then finally, what counsel suggested is that it was the tenant could decide after the foregoing period. Once again, the language of the lease is the imposition of continuous operation covenant then says after the foregoing period, the tenant has that discretion. We are within the period, the 1 year period. And as a consequence of that, to read that one sentence in 8.2.1 standing alone, I think does a disservice to reading the lease harmoniously and looking at each provision. The only harmonious reading of the lease I would suggest is to look at it as a whole. In 8.2, the parties agreed that the tenant would operate continuously for 1 year, subject to only the limited permitted exceptions or cessations. Those aren't present here. They further agreed that thereafter, after that 1 year period, there's no continuing obligation. And the tenant could then do whatever it chooses to do in terms of the property, thereby, as you suggested earlier, Your Honor, balancing the risks or the, if you will, the liabilities between the two parties. As a result of that, we suggest and we believe that the trial court erred in accepting the tenant's interpretation of the lease by essentially rewriting provisions and making a provision illusory, not being there anymore. And we suggest that was improper. If in fact it is ambiguous, as Judge Vellante may suggest, that also I think would suggest this